Okay, so good morning. My name is Shazia Khan, and today's session we are doing is learning outcome two. But before I go into learning outcome two, I just want to give you an overview of what we did in the last learning outcome, which is learning outcome one. We looked at explaining the nature of the legal system. We looked at defining what a legal system is in the UK. We looked at the purpose of law. We also looked at the evolution of law and different sources of law, like legislation, directives, case law, and treaties relevant to the country. We looked at the different divisions of the law, and we looked at the legal status systems, like the court structure. So, Supreme Court being the highest one, and down to the Magistrates' Court. We looked at what each court did, and we also looked at the difference between civil and criminal law and used examples to identify the differences. We also looked at the justice system in the UK and the role of government in lawmaking and the justice law and the organisation of the judiciary. So before we carry on with learning outcome two, I just want to know what do you think is the difference? Just to reiterate, what is the difference between civil law and criminal law? Keith, what do you think the difference
Criminal
is?
criminal law is when when you violate somebody else's rights.
Okay. And civil?
Civil law is disputes
Individuals.
against one another.
Excellent. Thank you. Yeah. So that looks at dispute against individuals. And it's not normally in the form of compensation would be a civil law case. So now we're going to go on to the business law learning outcome two, which is to illustrate the potential impact of the law on a business. So we look at the impact of law, we look at contract law, why that's important for a business, we look at the formation of contracts, elements and terms of a contract. We're going to look at competition law, data protection, and the tort of negligence, consumer protection, health and safety, and product liability as well. We look at duties of an employer and employee, the employment contract, employees' obligation and rights in the workplace, and also managing cases of dismissal in redundancy, discrimination, and health and safety. So, key terminology, we're going to look at how the law impacts on the businesses across every kind of way around both risks and the opportunities in areas such as, we have employment law, environmental law, data handling, and competition law. And how a business that ignores these legal requirements of, that they must follow faces severe consequences, like their reputation or fines as well. So the impact of law. So law is there literally to protect individuals. It governs society and makes sure that laws are there to provide safety for individuals. And it also looks at the social control and social transformation. So it's there to maintain social um, stability and also social order within the country, and also the behaviour, of societies and how they impact on legislation. Laws are also there for protecting individuals' freedoms and rights. So, what kind of right do we have as an individual? What do you think we have as an individual? What kind of rights do we have that must be protected?
Freedom of speech.
Freedom of speech, yeah. Even though they may not like it, Keith, freedom of speech is really important. We have freedom of privacy, our property rights. These are the whole point of having the impact of law. So the whole point is to, correct any sort of inequalities
Yes.
and make sure that, they are following the law. Okay. Then we've got the impact of law on businesses. What do you think the major impact of law is on businesses? What do you think it's there
Um,
for? Do you think the laws are there to protect businesses?
yes, they're there to protect
Yes.
businesses.
Yeah. What kind of things can be something that a business can do that, would not protect them.
Selling counterfeit items.
Yeah, yeah. So, you have is the whole point of the impact of law on a business is that it's there to protect its stakeholders, it's there to protect the people that own it. And also because, the legal framework includes employment rules, it could be things like, consumer acts. It's there to protect and build that trust and enhance any sort of employee satisfaction. It's there to increase costs, also to make sure that, uh, the business is reputation is not damaged. So we'll go on to look at the impact of law on businesses, and there's a video there that we can right click on, see if it opens up, and see if you can hear this video. And it looks, can you hear? No, no,
No.
no. Okay,
Yeah.
1 minute. So that could look at. Let's go back to that screen. Just go back. Just 1 minute, Keith. So let me go back to that. Where's the left to go back to getting that? So we'll have a look at the video. Have a look at the video in your own time. That video is
Okay.
around the impact of the impact of costs and laws in regards to
Okay.
legislation and how that impacts on individual businesses. So making sure that businesses are taken care of, making sure that businesses are run properly. The law is there to protect them. So have a look at that. Can you see the slides? Yeah.
Yes, I can see the slides.
Okay. So businesses will affect. What kind of things do you think of businesses will affect legislation?
Sorry?
What kind of things do you think they will affect in legislation? Will be affected by a number of legislation. So we have things like, employment law. Yeah. How do you think that will
Yeah.
affect business?
Uh,
And what do you think? What do you think covers employment law?
the contracts.
Yeah, the contracts, the working hours, Keith. It could be,
Yes.
the protection against any sort of discrimination, like if employees come back and they are, come back from pregnancy, taking into account flexible working hours, things like that. For health and safety, it makes sure you have to make sure that all employers are working in a safe environment. And that means, to make sure that they are a safe working environment, but also the equipment, you've given them training around health and safety because there could be issues around that. You have to do risk assessments, things like that. We have things like environmental legislation, which covers things like pollution and waste disposal, making sure that everything there's imposes rules on businesses to ensure that they protect the earth and make sure that there's no forms of pollution or anything. We've also got taxes, which it looks at income tax, business tax, sales, payrolls, and if taxes and fines will be imposed if this is not dealt with properly as well. So the legislation governs that. Another one that is quite important is the fact of data protection. Requires every business to protect its data. And make sure you're protecting uh, uh, you know um, personal data of individuals and reporting any sort of breaches that occur. Individuals' data is really important under GDPR. Is it a criminal offence if you know, you actually give the personal data to someone?
Or willingly or
Is it a criminal offence if you give personal data to somebody without, if you breach it?
uh,
You do get
maybe if it's
fines, you
willingly.
get legal actions and damage. There are consequences of these. If you don't follow these, are there consequences that occur? Things like, fines and legal actions.
Yes.
Yeah. So we have contract law. when we look at contract law in regards to any sort of business, contract law is where a legally binding agreement um, that requires elements of a contract. So you could have valid offer, acceptance, intention to create, and this governs the development and enforcement of contracts and ensures that remedies. So it could be things like, they have to be verbal or written. You need to make sure a contract is important in place in regards to between parties as well. Formation of a contract, how it's formed. So, like we said, there's an offer, acceptance, and consideration, along with parties that have intention to create the legal contract and capacity. A valid contract is formed when an offer is accepted, then a mutual exchange of something, which may be consideration, which is money, and then a legally binding contract is bound. Okay, so here contracts will take the different forms. What kind of forms will contract take in a business? What kind of things would amount to a contract in a business?
What kind of things will?
Amount to a contract? How would you make a contract for a business? What could it be like a business contract?
By stating the purpose of why
Yeah.
why we are why we are
Could it be an
doing this
employment
together.
contract?
Yes, it can be an employment contract.
Yeah. So contracts are formed through like written documents, spoken words, and contracts are, evidence that they are legally binding on an individual. So the elements of a
Okay.
contract is that, they have to have offer, acceptance, consideration, capacity, and for a contract to be legally binding, uh, valid, all these components must be present. So you need to make sure all the components are present. Without this, the contract is not a legally binding contract. Then we've got the terms of a contract. So contracts, what are terms of a contract? What would terms do?
For example, if you terminate the terms and agreements that you
Yes,
agreed on with the clients, the
yeah.
contract will be terminated.
Yeah. So a contract terms are specific provisions within a contract that define the rights, obligations of each party. So these contracts, like we said, could be express or implied. Okay, and they are important conditions, are major terms of a contract. And if they are breached, the contract, like you said, will end. So they have to take into account these contracts, and these are written into the contract to form the contract. So it's really important that these terms are taken into consideration. Otherwise, it's a breach of a contract. The next one we've got is competition law. So UK competition law is enforced by the UK Competition and Markets Authority, CMA, and it's really there to promote any sort of healthy competition by prohibiting any anti-competitive agreements, which are like, price fixing and bid rigging, and the abuse of dominant position, which are businesses must also comply with the rules, which can be blocked if they reduce any sort of competition between them. So, anti-competitive agreements is agreements between businesses that restrict competition, such as price fixing, market sharing, and bid rigging, and they are illegal. And then we've got the abuse of dominant position, and this is where businesses hold a dominant position in a market and are prohibited from abusing their power in anti-competitive way. So, these kind of elements, the CMA, which is the Competition and Markets Authority, can enforce penalties. Businesses can be fined, literally some businesses 10% of their annual turnover. And sometimes individuals can involved in any sort of cartel activity can face up to 5 years in prison or a fine. So there are, you need to comply with competition law as a business. The whole point of competition law is to protect the underdog or the consumer. And it's there to promote any sort of fair competition in the market, and it regulates mergers, and it prevents reduce competition and can involve market studies to address uncompetitive. And like I said, if you violate any sort of elements of competition law, the laws can include fine. A director can be disqualified as well in this, and also, imprisonment in some cases. And businesses should comply with competition law to avoid any penalties, and should have clear policies and training in place. These kind of. Do you think the businesses should train their employees when it comes to competition law?
Yes, they should.
Yes. And also, under the EU law, Article 101 and 102 of the Treaty of Functioning of European Union, where people, when we've talked about cartel activity, where, they are any sort of anti-competitive conduct, where it took place in EU and UK, this would be taken into account. Data protection, really important part of any sort of business. It's governed by the UK General Data Protection Regulation, which is GDPR, and the Data Protection 2018. And these are strict laws for how personal data can be collected, used, and shared with individuals. Organization and businesses that handle personal data must follow these data protection principles. And the Information Commissioner's Office, the ICO, is the UK's independent regulator. So it's really important that they follow, the laws around it. What could happen if data is leaked, or if it's someone uses someone personal data? What could happen?
Uh, the company might lose money,
What's that, Keith?
and the company might lose money.
Yeah. But also, is it a breach?
It's a breach.
Yeah, it's a breach because if the laws, the whole purpose of this act, the 2018 Data Protection Act, is to make sure that everyone's individual data is being protected, and how it's been processed. There are rules in place for GDPR, so it's really important because there is lots of elements of corruption and stealing of data as well. When we come to the thought of negligence, what is negligence? What do you think negligence is?
Uh, for example, if you know you're doing something wrong, but you still end up
Okay,
doing it.
yeah, if you're doing something wrong, and what if you're harming someone? Is that negligence? So
Harming somebody.
give me an example of where negligence will occur in a situation.
Uh-huh.
What about a doctor and
So,
a patient?
oh yeah, for example, instead of the doctor collecting vitals as it's supposed to do,
Yeah.
he ends up clearing the patient before even testing them.
Yeah. So, negligence is a legal wrong, okay? And it's where a person's failure to exercise reasonable causes injury or loss to another person. So, for negligence, to occur, there are different elements of negligence. First, that the defendant have a legal obligation to provide the plaintiff with a duty of care. They have a duty of care. Breach of that duty, they failed to meet the standard of care, and the defendant breach was direct, and then the plaintiff suffered a loss. So these are foreseeable things that applied in the law of tort. Consumer protection is a UK law under the Consumer Protections Act 2015, which gives consumers rights over faulty goods, services, and digital content. And it's faulty goods. They can apply for get a refund within 30 days and a right to repair. They've got a replacement and then 14-day period to cancel without orders. And rights for faulty goods could be things like repairing or replacing, and the time limit they have in regards to that. So you have the right to cancel. You have the right to a full refund. And the Act protects consumers in relation to any sort of digital content as well. And that can be things like apps, music, and software, and it also protects individuals for services, the right to regarding the quality and performance of a service. So these are elements that need to be followed when it comes to the Consumer Protection Act. The Consumer Protection Act sets out protection for individuals. Okay, it's there to make sure that the consumer is protected and any sort of they're not treated unfairly, and they if they have made a purchase, that they have the our business has followed the protocols. They gave him the example here before. For an example, excuse me, before making an online purchase of goods, consumers in the UK must be given all the information about the transaction and can cancel the contract and the return of goods within 14 days, whether or not they are faulty. They're also protected against a wide range of prohibited, unfair, misleading, and aggressive business practices, many of which are criminal offences and in relation to which a consumer may have a right of redress. Terms in goods and service contracts which are found to be unfair and invalid or non binding. Then we've got the health and safety measures. Now, these are really important when it comes to any sort of workplace, to make sure that health and safety laws are protected. They are measures to prevent any sort of harm or illness to anyone and injury in workplaces and public spaces. So, key aspects is that businesses have a legal and moral obligation for employers to provide a safe environment, which includes things like risk assessments, providing proper training and equipment, and implementing safety policies. Employees also have a responsibility to follow safety procedures and report hazards, So it's not just up to the employees, it's up to the employer as well. Organisation like the UK's Health and Safety Executive, which is the HSE, he actually is a government agency, and he's there to enforce any sort of regulations, conduct investigations, and provide guidance to businesses. So if something hasn't been followed, they are there to provide that guidance. And when you look at employees' responsibility, they need to develop a health and safety policy in the workplace and conduct risk assessments. They need to provide a safe environment, like we said. They need to provide training and information. Why would they need to provide training, Keith? Why do you think training is so important?
Um,
If you're an
so that they
employee,
can
why do you need to provide training?
to improve
To make sure what?
work
Sorry.
efficiency in the company and
Yeah.
to educate
But yeah,
to improve work efficiency.
yeah. But is it to make the workplace safe as well?
Yeah, also to make it safe.
Yeah, because if you're working in a factory and you're using machinery, you need to be trained on that machinery, don't you?
Yes, you need. Yes, you
Yeah.
do.
And businesses need to ensure that health and safety measures comply with the law. If you don't do that, then you would be shut down as a business. They need to plan, implement, monitor, and review safety measures and ensure they are effective. Employers need to take responsibility for their own safety, and follow all the health and safety protocols and procedures. And if there's any sort of hazards or anything, they need to start reporting them.
Yeah.
So product liability is really important when it comes to businesses as well. And this in the UK manufacture, it's a liability law in the UK, and it holds manufacturers, distributors, suppliers and legally responsible for damage caused by defective products under the Consumer Protection Act, 1987, meaning that a consumer can claim compensation for death, personal injury, or damage to private property without needing to prove negligence, as long as they can show that the product they've got was defective and caused the harm. So a defect can be due to a design flaw, maybe. It can be an error or inadequate warnings or instructions. So, a claim arises when a defective product causes harm, and the law protects consumers from unsafe products. It holds those in the supply chain accountable for the safety of the product, and claims can be made. And that can be things like, it could be a defective product, could be a Hoover, it could be a microwave that's blown up, it could be a kettle, it could be anything that has caused damage to the individual as well, or any sort of harm, and then they are liable for that. Product liability is, really important for manufacturers, distributors, suppliers, and reasonables, because they are held responsible for it. And they need to make sure that, products aren't, safe. Could it be a criminal offense if someone dies from this? If you,
Yes, it can
if
be.
you, if
There's
yes,
some
if
other
you
thing.
know, Keith, if you know your product is unsafe, could that be a
Uh-huh.
criminal offense if you sell it to someone?
Yes, it is.
Yes. They could be held liable, they could be criminally liable and responsible for breaking the law if they know that the product they are selling is faulty, because it's caused harm to the other person. So, it's really important that businesses make sure that they check all their products and they do not sell defective products or, provide any sort of deficiency of services. Because if it causes harm to the individual, then they are liable. And, they are liable under a court of law, and they can be sued. Legal action can be taken against them. So, they need to make sure that they cover all the elements of that. Duties of employers. So, duties of employers' responsibility include providing, like we said earlier, a safe workplace. They need to provide training. They also need to be paying employees correct, providing benefits like holiday and sick pay, and complying with elements of employment law. They are there to implement safety measures, pay the correct salary, and ensure fair treatment and equal opportunity. So, for example, if it's an employer, they need to provide a safe place for their employees, make sure that safe equipment is there, make sure that training is put in there, make sure they conduct risk assessments. Why are risk assessments important in health and safety? Why
To
are risk
minimize the
assessments?
risk in the company.
Yes. But is it a risk to the individual as well?
Yes, it is.
Yeah. Making everything safe. Excuse me.
Mm-hmm.
Also, they need to provide information and training, like we mentioned earlier, to make sure everything is safe. They need to ensure that first aid facilities are available, toilets are available, ventilation is available, and they need to provide PPE products as well. Pay is really important. They need to be paying the national minimum wage and deduct that from tax and national insurance. They need to provide leave and pay, so ensure employees receive their legal holiday entitlement, statutory sick pay, and statutory parental pay, and also pay employees for untaking untaken holidays. And also, they need to give employees a written statement of their employment terms. They need to follow all the relevant legislation, and they need to contact HMRC as well. And they need to look at if there's any sort of elements of employers that want flexible working hours. They need to take that into consideration. It's really, really important that employers maintain a relationship of trust and confidence, and do not discriminate against employees, because discrimination is one of the biggest elements of employment law. So, duty of an employee. So, it's not just the duties of employers; it's duties of employees as well. Employees' responsibility is that they act with reasonable care, and of their own safety, and obey lawful orders, maintaining confidentiality, making sure they're following health and safety procedures, making sure, they are involved, taking into account any sort of policies, and, they are making sure they are performing their duties for the employer. If there's any policies to follow, they are consistent at following them policies. They need to provide personal service or perform the work themselves. Employees also need to maintain confidentiality as well, and trust. They need to be flexible and willing to adapt to evolving teams and the new ideas as well. Employees also need to, like you said, take reasonable care of themselves, make sure they are following the policies, and make sure they are, using equipment that they are trained on, and not just using any sort of equipment, reporting any concerns, any hazards, any illnesses or injuries, and they need to avoid, misusing any sort of equipment and provide health and safety purposes. The employment contract is a legally binding agreement between an employer and the employee, and it outlines the terms and conditions of their working relationships. What things can go in an employment contract, Keith?
The salary, how
Yeah,
long you're going to work for,
yeah,
and the hours.
yes. Could it be things like their duties as well? What their job
Sorry?
is?
Oh
Could
yes,
it
yes,
outline
the
what
job
their
is
job is?
yes.
Yeah. So it outlines things like pay, working conditions, your job entitlement, your duties, your holiday entitlement, and how long it identifies your pay as well, your working hours, like you said. So it should include your leave entitlement, what holidays, sick pay, maternity pay, any sort of paternity leave. And other things that it may have in is like company policies and a code of conduct. So this occurs if when a job is offered. So if a job is offered and it's accepted, then a legally binding employment contract is formed. And employers legally have to provide a written statement detailing the employment contract. A contract is a combination of written documents and verbal agreements, and it defines the rights and responsibilities. So it's really important because this helps in individuals. So the employer's rights and obligations under with the contract. So these primary responsibility include providing a safe and healthy workplace, making sure that there's uh, they pay the minimum wage, and offering statutory benefits like holidays and maternity pay. And employees responsible for making sure the business follows the relevant regulations, any sort of code of conduct, any sort of fair treatment in the workplace, and your responsibility as an employer include things like, fair recruitment practice you put in place, make sure that, you are providing written particulars, so that's a contract of employment, also health and safety and working time regulations, and making sure that holidays are put in place and minimum wage. They also have the right to employees have the right to expect employees to obey lawful orders, and reasonable care and compete with like the business. So they need to make sure that all these are put in place, and the employers expect the employers to exercise reasonable care and skill in the workplace, and make sure the employees act in the best interest of the organization. Employers' rights and obligations. So employers' rights and obligations are things like fair treatment, which prevents any sort of claims of discrimination, their duty to consider flexible work. So, you have a duty from an employee consider flexible working hours, and that might be a mother who's come back from maternity leave and that wants to work flexible hours because of a newborn child. The duty to grant maternity leave, they have that duty, parental leave and paternity leave. Also abiding by express and implied terms, informing and consulting when changes are made, pensions, termination of a contract. These are all responsibilities of the employer, and these are part of the UK law, employment law. That they provide a safe working environment, that they pay minimum wage, that they provide, pay slips, and they provide holiday entitlement, maternity and paternity pay, that they provide a written contract, fair treatment, so that they protect any sort of staff from any forms of discrimination, and they promote any sort of diversity, and the whole point of discrimination is trying to prevent it in the workplace. Also, that they, like we said, that they conduct a fair recruitment practice and ensure dismissal is fair and lawful. That they also ensure employees do not work longer than the maximum legal hours and comply with working time regulations. And the other thing, the most important thing, is to register them with HM, revenue and customs for payroll, if there are any sort of requests for working hours. So, employers' rights and responsibilities are to ensure that they provide these for the employees and make sure throughout the workplace that they provide the services, for the employee. The next element is looking at dismissal. So, dismissal is when an employer ends your employment, okay, which can happen with or without notice and is known as being sacked or fired, okay. Um, the when you have, for the dismissal to be fair, the employer must give you valid reason. It must follow reasonable, fair procedure. If the employer dismisses an employee unfairly, the employee may be able to challenge this as dismissal, especially if they work for the company over 2 years or not. What grounds can someone be dismissed on, Keith?
Sorry?
What grounds can someone be dismissed on?
Violation of the contract.
Okay, violation of the contract. What else can an employer be dismissed on? What if
Mhm.
an employer is always coming to work late? Can they be dismissed on that?
Oh, yeah. Yeah,
Yes.
yeah, they can be dismissed.
Yeah. So, you can challenge a dismissal. It could be constructive dismissal where the employer resigns because of the employer's conduct, or it may be wrongful dismissal where the employer dismisses an employee on the breach of contract. So, dismissals, reasons for being dismissed, it could be, that the fact that you know, you mean your work that you're doing is not satisfactory, and it may be the fact that you are always coming late to work, or you've done something which has caused this dismissal. It may be that your capabilities or qualifications that you've lied about, and it may be redundancy. It may be that it may be where you're unlawful in your workplace. So, there are different reasons for being dismissed, and the main three types of dismissal are unfair, unlawful, and protection dismissal. And these happen if something occurs within the workplace. Managing cases of dismissal. So managing cases dismissal following a fair procedure. So you need to follow a fair procedure, which includes providing clear, reasonable reasons for giving an employer the chance to appeal and handling final meeting care. So, before dismissal and action, you need to carry out investigation, you need to hold meetings, and you need to consider alternatives to dismissal. You need to also, if it's capability, issue warnings, handle gross misconduct, and you need to be, for dismissal meetings, they need to be direct, and honest about it, and prepare for negative uh, reactions. State the facts of the case, provide the employee with the reasons for dismissal, and then focus on the next steps. It could be after dismissal, they have inform the employee they have a right to appeal to the decision, and how they can do this. Also inform remaining staff members about the departure while respecting the privacy of the dismissed employee, and communicate the final decision in writing after the appeal. So, you must be respectful of the individual employee's professional reputation. You can't just be saying, oh, we've dismissed them on this basis and talk about it. Okay, so you need to make sure that you have given reasons for the dismissal, also why they've been dismissed, and it could be put in writing. And if the employer feels that the dismissal is unfair, they can appeal against the dismissal, but they have to follow a procedure in place as well. Otherwise they may have a claim for unfair dismissal if it's not followed. Managing cases of dismissal, again, elements of managing cases of dismissal. Like we said, they have to put it in writing for an employer, and employers have a right of appeal, and employers have the right to ask why we've been dismissed. And it's always, if they've been employed for 2 years, they have that right. If they've been employed for less than 2 years, then they don't have that right. And then an employee can appeal, like we've said, they have the right to appeal, they have the right to follow the procedures, and make sure that appeals are put in place. And if they feel that it's an unfair dismissal, they need to, even if the reasons are, they need to make a claim for that. Managing cases of redundancy. So an employer managing redundancy in the UK must follow also a specific process to ensure legal compliance and avoid any sort of claims of unfair dismissal. This involves things like planning, exploring alternatives, conducting fair consultations, making sure you follow the process, which has different steps. So the first step could be things like strategic planning and exploring alternatives. Second step, consultation. Third step, fair selection. Fourth step, alternative employment, redeployment. Fifth step, notice and termination. Sixth step, pay and support. And then, throughout the process, it needs to protect the business, but also protect the individual in regards to the rationale for the redundancy. Employers again take reasonable steps to avoid redundancy, manage redundancies legally, and in a way they minimize it, implement communication strategy, and ensure everyone has the correct information. Managing cases of discrimination. So when discrimination cases are come about, employers must follow a fair and confidential investigation process, adhere to company policies, and take the appropriate actions as well. They should provide guidance for employers, such as trying to encourage any sort of resolution. Also, listen respectfully and follow procedure. And you need to make sure you appoint an impartial investigator who's impartial, who doesn't know anyone, and who's neutral. They make a complaint, you need to make sure there are alternatives. The complaint can go to the employment tribunal, and then they will make the decision based on that. Managing health and safety. So, managing health and safety is a continuous process for a business. They should make sure they're on top of things and make sure there's assessing risks, implementing control measures, and reviewing the effectiveness. Employees must appoint a competent person, plan, organize, control, and monitor any review safety measures, and consult employers with workers to ensure a safe environment. They should, identify any sort of hazards, assess any sort of risks, and record everything. It's really important they do this at every stage. They should consult their employers. By following the plan, do plan, do check, act approach. You need to plan what you need to do, right? To implement your plan, check your control measures. Active measures are not working. This will help find out, if there's any improvements. They need to use a continuous improvement cycle, and they need to check the results and consult their employers and make sure they provide any sort of training. So these are the references we've used for today's session that you can right click on if you want to use them. So we've gone through elements of learning outcome 2, which is to illustrate the potential impact of the law on business. We looked at elements of the impact of law. We looked at impact on businesses. We also looked at businesses being affected by a number of pieces of legislation. We looked at contract law, tort law. We looked at the formation of a contract. We also looked at competition law and anti-competitive agreements. We looked at data protection laws. We also looked at the tort of negligence as well in today's session, and also looked at the element of health and safety, product liability, duties of an employer, duties of an employee, the employment contract. We looked at employers' rights and obligations. We looked at dismissal, what dismissal is, managing cases of redundancy, managing cases of discrimination, and also managing cases of health and safety. So these are what we've looked at today. This is the guide, these are the references. Have you got any questions, Keith, before we finish the session off? Keith, have you got any questions before we finish the session off today?
No questions.
Sorry, what was that, Keith? Sorry.
No questions.
No questions.
I'm good.
Okay, so this is just an overview of what we've done in Learning Outcome 2. There are some queries. If you've got any queries or anything, you need to email learnerwork@ukvarsity.co.uk. Submission of your assignment is to be done on learnerwork@ukvarsity.co.uk. Assignment submission is 2 weeks after the completion of the unit. So now we've covered Learning Outcome 1 and 2, and we've got Learning Outcome 3 tomorrow. And then once you've done all the learning outcomes, we have an assignment discussion, and then you are able to get on with the assignment. If you have any questions or if you need to check anything, additional reading is available on Moodle for you. Any sort of other resources are all available on Moodle for you. If you have any questions, just email learnerwork@ukvarsity.co.uk. So the next learning outcome is learning outcome 3, which we've got tomorrow, and then you could the rest of the learning outcomes are next week. All these are recorded and they will be uploaded onto Moodle for you to have a look in your own time and any sort of additional resources. Okay, thank you for attending
Okay.
today's session. If you haven't got any questions, we'll finish the session off now. Is that okay?
Yeah, that's okay. That's okay.
Thank you, Keith. I'll see you in tomorrow's session. Okay,
Okay. Okay. Thank you.
thank you. Bye.
Bye.